Hello folks, welcome to the Wikipedia world. I am Abhinay Gupta. So today again we'll continue with the topic, the compromises, arrangements and amalgamation of companies, which is being covered under the Companies Act 1956. Right? So what have we seen in our previous lectures related to this subject, related to this chapter? We have understood the meaning of the compromises, arrangements and amalgamations. We have seen the procedures that have been followed, that has to be followed for the compromise and arrangement, which is under section 391 to 393. We have also seen section 394, which was the reconstruction or amalgamation by sale of undertaking. Right? We have seen all the procedures that have to be followed, how an application is made to the court, what does the court do with the application and the scheme, how does it evaluate it, how does it approve it. Now, when does it send it to the CG for representation? What does it do with the representation? Then it directs the company to call the meeting, and then it finalizes and understands whether the scheme is bona fide and workable. If it does, it approves the scheme. Then it supervises the scheme and modifies it if necessary. And even though it turns out to be not workable, then the company is wound up. We have seen the powers of the court for the same, right? And in the case of reconstruction and amalgamation, we have seen how two companies approach the court with the application and scheme, what are the content, how the court reviews the scheme and passes the order for amalgamation. And in both the case, the amalgamation or the compromise and arrangement comes into force, comes into existence only when the final scheme or the order of the court is filed with the registrar of the company, and then it is binding on all the parties. So that is what we have seen so far. And we have seen that the court plays the most important role. Everything is decided by the court, and it is the discretion of the court in most of the cases. And the court is given a hell lot of power. Right from holding the suits and proceedings to directing the meeting and winding up. But today, what we see is section 395, which is the reconstruction by sale of shares or takeover. And this is far different than the procedures that we have seen in the previous sections. The previous section, section 391 to 394 of the Companies Act 1956, I repeat 1956, the sections have been a little cumbersome with regards to the procedures to be followed. Right? It is a little cumbersome sending applications, waiting for the results, the directions of the court and stuff. Right? So to do away with these and to give you a little comfort, section 395 comes into play, right, which enables the company to acquire the share of another company and hence take over the controlling rights over the other company. Right? It enables the transferee company to exercise control over the transferer company. It is actually a process which is known as the takeover. Right? And it does not involve the intervention of the court at all. It is done by the agreement with the directors, by an open market purchase, by takeover bid, etc. Right? But the court has just one simple role to play, that is to solve a dispute. The dispute that the dissenting shareholder has with the transferee company. So unless the dissenting shareholders approach the court will not interfere in section 395. So the procedure becomes simple and crisp, right? And it is the way the transferee company wants to take over the transferer company. However, or whatever is the procedure that it wants to follow to take over the company to purchase a share, it is its discretion to do so. Right? It has no interference of the court. So what is takeover bid exactly? So takeover bid is an offer to acquire the shares, and that is also where the shares are not closely held, obviously. Right? It is an offer to purchase the share against the cash or shares of the transferee company itself, or partly by cash and partly by share. However, the transferee company feels like taking over the shares. Right? And they also have the power to acquire the shares of the shareholders who do not consent to the transfer. That is the takeover bid. Right? So now let us get into and understand the procedures that has to be followed, right, for the reconstruction by sale of the shares or by takeover. So the first is an offer to acquire the shares. The transferee company who wants to acquire the share of the transferer company will make an offer to the transferer company that they want to acquire the share, and this is the price I would like to offer for your shares to your shareholders. Now tell me whether or not you people are willing to do so. And with the offer that they make, they will also prescribe or define the maximum time limit within which the transferer company will have to revert back with either their acceptance or their rejection. And this time period, as per the Act, as per Section 395, can be a period of maximum 4 months. Right? So what we see is that the transferee company gives an offer to the transferer company, stating the price that they offer for each of the shares of the the transferer company. I hope it is clear with you people what is transferer company and what is the transferee company. Transfer is the word, right? Which means that you give away something to the other person. So the person who gives it away is the transferer, and the person who takes it is the transferee. So over here, if you are selling away your shares, you are the transferer, and the company who is buying your shares is the transferee company. So please keep these things clear, because moving ahead with the lecture, this is what we'll refer it to. We'll always mention the word transferee company and the transferer company, right? So the former company was the transferer company, and the new company is the transferee company. Now the stage 2 is the acceptance of the offer, right? The transferer company who has to give away the share will have to accept the offer. Now the acceptance will be valid only when 90% of the shareholders of the transferer company accept to sell their shares for the desired price, right? For the given price, the price mentioned in the offer. And one important thing to be kept in mind for your exam purpose also, like for your practical exams, in law when you have the practical questions, that the 90% is the 90% of what? Like if a company has 1000 shareholders, is it the 90% of 1000 shareholders, which is 900 shareholders? The answer is maybe. Why maybe? Because there may be some shareholders, right, of the transferee company itself who are holding the shares of the transferer company. Like Mr. ABC are the shareholders of the transferer company, and XYZ are the shareholders of the transferee company. So there is a possibility that Mr. Y from the transferee company holds around 100 shares of the transferer company. So how many shares do A, B and C have? The sole shareholders of the transferer companies, they have 900 shares. So we will consider 90% of this 900 shares, which is 810, right? So this is how you put it forward, that 90% of the shareholders of the transferer company, right? The shares that are held solely by the transferer company. If the transferee company has a person who holds the share in the transferer company, the shares of that person will not be valued for calculating the 90%, right? And the time limit for accepting the offer is the time limit already mentioned in the offer. With the offer, the transferee company has specified the time limit within which they have to accept the offer. So if they accept the offer within that time limit, it is valid, else the offer is closed. Right? So we move ahead to the next stage. Or wait, before moving to the next stage, we have some duties of the directors that we are supposed to understand, which is a part of stage 1 actually. Right? There are specific duties. The duty of the director, they have to give certain information to the shareholder. When the offer comes, the shareholders have to be informed about certain parameters, and certain information have to be provided to them so that they decide whether or not they want to give away the shares to the transferee company. It is the duty of the directors to be honest, because if they mislead the shareholders and try getting their consent, the moment 90% of the shareholders consent, the entire company goes for a toss, and the minority will keep complaining. So the board of directors of the company have certain duties. Now what are they? So every officer, or of the company has certain responsibility towards the shareholders. So when they make any recommendation to the members that yeah, we have this offer, we make you a recommendation to please sell your shares, they will have to accompany the recommendation with some informations, basic informations. Who is the company? What does it want? How much is it offering? What do you have to do? What is the benefit that you will get out of it? Right? These are the basic things that they have to inform. And then they will also have to attach a statement that has been received from the transferee company, which will ensure that the necessary payment, the cash, will be available with the directors to pay off the shareholders once they surrender their shares for the transferee company. Right? And every such offer that the transferee company makes to the transferer company will have to be registered with the ROC. If it is not registered, it is not a valid offer. Right? And the registrar can deny, can refuse to register it if it does not contain the required and the relevant information. So here the shareholders are being given a surety. Like there is this control, there is this check which will enable the shareholder to get the complete information and true information. Right? So whatever offer the transferee is making, it cannot be a very fraudulent offer because they'll have to get it registered with the ROC. And ROC on its end will do all the scrutiny and the checking. They will want the basic informations before registering it. They have to be satisfied that yes, the offer is viable, and then they will register the offer. And then the offer goes to the board of directors, they will recommend it to the shareholders, and then also accompany the statement of the informations. Right? And another statement which will ensure that yeah, the cash will flow in if you surrender your shares. Right? And the appeal shall lie to the court against any order of the registrar. If the registrar refuses to accept the offer, the transferee company can appeal to the court. Right? And the directors, they will not receive any payment by way of compensation from the transferer company. If they have to receive something, they will receive it from the transferee company, which is the new company. So these are the basic duties of the director and the procedure that takes place between reception of an offer and sending out or taking the decision. So this is what is the gameplay between them, right? And then the next stage was the acceptance of the offer. If 90% accept before the expiry of the offer, it is accepted and it is valid and it will move ahead. Then the next stage is the acquiring of the shares of the dissenting shareholders. Now, here we have seen that 90% of the shareholders have agreed to give away their shares. Maybe 100%, maybe 90, 92 or whatever. So there are some shareholders who has refused the offer. They don't want to go ahead with that. Now these are known as the dissenting shareholders. So dissenting shareholders are basically the shareholders who attend the shareholders meeting and vote against the resolution. And it is not compulsory that they attend the meeting. Even if they are absent from the meeting, they can send their objection within 30 days. Right? So these shareholders will be known as dissenting shareholders. That we are not ready, we are not prepared to give away our shares to the transferee company. Now, the transferee company, right? After 90% of the shareholders have given their consent, that means they will now take over the company. So the remaining shareholders, who are the dissenting shareholders, are now at the mercy of the transferee company. Now it is the discretion of the transferee company whether it wants to go via the method of compulsory acquisition or something. So if they want to, then they will give a notice to the transferee company, to the transferer company's dissenting shareholders that guys, we will be overtaking your shares soon. Right? And this has to be given, this notice has to be given within 2 months from the end of the period of offer. Right? And once the shareholders have received this notice, now they're eligible to appeal to the court that our shares are going to be taken over compulsorily and we don't want to give it to them. So please help. Right? And unless and until they get a notice for the acquisition of shares, they can do nothing because nobody has approached them. Nobody is bullying them. Nobody is taking their shares away. Right? So we can say that the transferee company has the right but not an obligation to acquire the share of the dissenting shareholders. Right? And if they want to make a compulsory acquisition, it has to be done within 2 months of the expiry of the offer. The next stage is stage 4, where the dissenting shareholders make an application to the court. Right? Now, who has the right to make the application to the court? Or when do they have the right to make application to the court? So, the right to make an application vests with the dissenting shareholders, and it will be vested upon them only when the notice for compulsory acquisition by the transferee company of the shares of the dissenting shareholders are received with the dissenting shareholders. Now they know that yes, the transferee company is coming to take the shares away. Now they want protection, and then they approach the court. But now even the court doesn't want a mess in the case. So what it says is, once you get the notice for the compulsory acquisition, if you object it, then please come to me within 1 month. Right? So make a valid application within 1 month from the date of receipt of the notice from the transferee company. If you don't do it within 1 month, I will not be able to help you at all. This is what the court says. Right? Now we summarize what are the time limits that that have been given to us in the past lecture, in this lecture, so that it is easy for you to memorize if you have all the time limits at one place. So we have 4 months is the maximum period of offer that the transferee company gives to the transferer company. That is the maximum limit. You can give for 1 month, 2 months, 3 months, 3 months, 30 days, 3 months, 15 days, 20 days, whatever. But you cannot go beyond 4 months. Right? And then you have 2 months period for the compulsory acquisition. If you want to make a compulsory acquisition, give them the notice within 2 months that yeah, we are coming to take your shares. Save it if you can. Right? And then once that notice is given to the dissenting shareholders, now they have a time limit of 1 month to file an application to the court. So 4, half 2, half 1. This is how it goes. So it is easy for you to memorize and remember. Right? Now the next is stage 5, where the order of the court for valuation is passed. Now what happens in this stage? So generally the court does not intervene, where the valuation is done by an external expert. Right? But yeah, now there lies exceptions. There are 2 exceptions. The court will intervene if the scheme is obviously unfair, patently unfair, and unfair to the meanest intelligence. We have discussed these 3 specific phrases in our previous lecture. So if you want to re-understand these, please refer to the previous lecture. Right? We'll move ahead with the class. And the second thing is, when can it intervene? It can intervene if it is demonstrated beyond all reasonable argument that the amount offered is inadequate. You don't need any argument for that. It is beyond that. It is what a layman can see and tell that okay, this amount for this share is very inadequate. This is not a respectable amount, and this is not a worth amount for that. Right? And now the burden of proof that the scheme is unfair lies with the dissenting shareholders. So if they object, if they appeal to the court that they have given us a notice of compulsory acquisition and we don't want to give away our shares because we don't feel that the amount that we are getting for the shares, the amount that we are getting in exchange is adequate, right? So they can make an objection. But if they make an objection, then the burden of proof lies on the dissenting shareholders. They have to prove that it is unfair, right? And the court will also see whether the transaction, whether the offer is unfair, right? But for this, it will see whether it is unfair for the entire league of shareholders. It is not only for those specific shareholders who have made the application. It will generalize that if those shareholders, 90% don't have a problem with that, what is your problem? Mere criticism or a scope of improvement in the scheme will not be considered over here. Over here, what we're talking about is to prove that the scheme is unfair, which is obviously and convincingly unfair, or it is fraudulent or improper. Now, to presume that the scheme is fair, we can also take an approval from the financial institution. That is the basic presumption that the scheme is fair. Now, what happened over here is that the financial information are generally well informed, right? They examine the scheme and they are expert in this field, right? And they act in a very specified, designated and a bona fide manner. So as such, the approval by the shareholder and the financial institution, right? All the financial institutions that are holding as much as 41% of the shares will create a presumption of fairness. right? So if they're involved and they say that the scheme is good, they are okay with giving away the shares, that means that the offer is fair. And that is one basic point where the notice or the application of the dissenting shareholders will be overruled. It will be just set aside. Because if the financial institution says it's fair, I don't think that you are capable enough to say it is unfair. They are experts, right? And since the valuation is also done by the expert, so the court will not interfere unless it is demonstrated beyond all reasonable argument that the amount offered for the exchange of share is inadequate. Right. Over here we had the case study also, again referring the same C6 Bricks Company Limited that we have referred earlier. Now we go on to the last stage, which is the acquisition of shares of the dissenting shareholders. Right. Now what we need to see is whether the application was actually made or not, and if it is made, is it rejected or is it allowed. So the first case is if the application is not made, or it is made but it is rejected by the court. So in this case, the transferee company becomes entitled as well as bound to acquire the shares of the dissenting shareholders, right? And this acquisition will take place at the original offer that they made to all the shareholders. It will not be something new for the dissenting shareholders. It is not a penalty. They should not be penalized. So the court says there will not be any modification, right? So whatever you had offered originally, even though you're not very happy with the dissenting shareholders, you will have to offer them the same amount, right? And now on the other hand, if the application is allowed by the court says, okay, the scheme is unfair and will accept your application and put a restriction on it, then the transferee company shall not have any right to compulsory acquire the shares of the dissenting shareholders. The shares will remain with the dissenting shareholders themselves, right? So now let us get deep into it and understand how does the compulsory acquisition take place, right? What will happen is that once the court dismisses the application and says, okay, transferee company, go ahead with the compulsory acquisition, then what they do is they send the transfer documents to the transferer company, and with the document they will attach the copy of the notice that they had sent to the shareholders, right? Then the transferer company, they receive the transfer document, right? And they will also receive the consideration for that shares. So the consideration is not being given to the shareholders, it is being given to the transferer company. And now the transferer company is bound to register the transferee company in respect of such shares, because the register is with the transferer company. So what they will do is they will strike off the name of the shareholders who have been holding those shares, the dissenting shareholders to be very specific, and instead they will add the name of the transferee company. So now on, these shares vest with the transferee company and not with the shareholders, right? And this money that the transferer company has received from the transferee company will be held in trust with the transferer company. Because this is the money that belongs to the shareholders whose shares have been taken away by the transferee company. And since it is the original compensation, so they know what the amount is. So whenever they wish, they can come and they can collect the money from the transferer company, right? So I hope the entire procedure is very clear with you guys. So this was the entire procedure of how the sale of shares takeover, reconstruction by sale of shares take place, right? And there is no intervention of the court, and this is unlike section 391 to section 394. This was section 395. So far we have covered 3-4 important sections, and with this we'll end up the class today. And until next time, this is Abhinay Gupta signing off. Thank you so much for the views.